I want to thank Honorable Sagara Karyavasam for actually bringing this motion, because in my opinion, the biggest problem facing this country is actually the problem of its judicial system. I think even the economy can be fixed if we can fix the judicial system. The law's delays is a huge problem. As we all know, justice delayed is justice denied. Inefficiency of the administration. And I'm not talking that only the administration inefficiencies in the judicial system. It's there across the country, but in the judicial system included. And the cost to the public, both financially, in terms of time, and emotionally. A young girl who has been sexually abused, the case is heard when she's a grown-up, married, maybe having children. And you can imagine the emotional cost to that young mother. So it's not the economy. We need to fix the judicial system of this country. I challenge anyone to take an opinion poll of some of the arguments that are coming up in the House today. It is not a criticism of individuals. It's a criticism of a system that needs to be changed. And I speak today from the perspective of the public of this country. We need a change. I am comforted by the fact that there are people in this profession who are equally not satisfied with how the system works and actually wants to see the necessary changes. If I were to just start with two stories. I was visiting the Sri Jnana Vimala Buddhist Center in Moratuwa. The Venerable Udugama Vimala Kirti is the chief incumbent or the priest in the temple. And he said to me, I went to court over a case. The case had been going on, postponed for 8 years. Finally, it was heard. And on the final day I went to give evidence, I noticed that 30 cases had been listed. 27 were taken up in the first 30-40 minutes just for postponement. And then ultimately 3 cases were heard, one of which was my case. And he said to me, each time it was postponed, I paid rupees 50,000 to the attorneys. And it went on and on and on. And I was wondering, why did we postpone 27 cases? Couldn't we have told these people, because I'm coming for justice after 10 years, couldn't we have told these people, come in 10 years from now, the case will be heard and you pay 50,000 rupees once. Now this is the view of the public. Another story I recollect is when President Maithripala Sirisena was in office, he summoned everybody in the judicial system and he wanted to talk about the delays in laws. So he called me also. And I asked him, why am I being called? He said, you're acting Minister of Finance. Could you also please attend this meeting? I went for the meeting. And all the problems were presented. And then President Sirisena said to me, what can you do about this? And I said to him, we can provide resources for increasing the bench. We can provide resources for increasing the Attorney General's department. We can provide resources for training and for human resources. But I said others might disagree with me. But I must say this. There's one thing. We are a poor country with limited resources. And when we are putting our resources, we need to be clear where we are going to put our resources. And we should put in human resources. But I said I would not put it on infrastructure. Because if you have to make decisions and choices. I remember as a young boy going to a government school in Colombo. My mother one day told me, you're not going at 7 in the morning to school. You're going at 1 in the afternoon to school. And I actually went for a whole year in the afternoon. I asked my mother why. She said there are no classrooms. It's a government school. Therefore you have to go to school in the afternoon. Our physical infrastructure is only used half of the day. We have to think out of the box. The Justice Minister and the former Justice Minister are here. There are limitations in terms of resources. We have to think out of the box if we are going to resolve this issue. A day is a day in terms of time, but a court could be more than 1 day. And therefore, I'm just putting that as a case that if we are going to really resolve this in favor of the people in this country, we have to think outside the system. The pending cases were discussed in 2019, 763,000 cases. In 2021, nearly 1.1 million, an increase from 2019 to 2021 of 43.6% of pending cases. I know there was COVID and disruptions and all, and that's why the excess. But the fact is, it's a huge excess. And these are Ministry of Justice Statistics Unit information that I am providing here. While that is true, also, when we need to speed up a case, everybody is on it. We had a situation where, a prospective candidate to become the IGP of the country, the case was brought, speeded up, the case was concluded, and the judgment just given a few days ago. But yesterday, it was very, very unusual that after the judgment has been given on this case, that the attorneys bring a motion to court and are requesting that a part of the petition that they had filed, particularly in reference to the present president of the country, that be basically withdrawn from the judgment. It really calls into question the system. This is unprecedented. Professors of law could comment on this more than me, but it's unprecedented on a concluded case that the petition to be amended. So you are asking yourself the question, what is the integrity of the system? What is the integrity of the attorneys appearing? What is the integrity of the judges to even entertain such a thing? Is there more to this politically? When we talk about laws delays, often it is said that in every country there are laws delays, and therefore, we should not be using this for an excuse. There are many reasons for delays. Where inadequacy of courts and judges, we heard, lack of training, we heard about it today, and there are all kinds of other deliberate delays on the part sometimes. Delays on part of law enforcement, judicial medical officers, forensics experts, analysts, archaic legal procedures, many issues why there are. And as the former minister said, we increased the bench during the 20th Amendment. But really, in terms of speeding up cases, there is no visible improvement. And then we see, particularly I would say on commercial cases, you're wondering why Sri Lanka has no investment. It's to do with the problem in the judicial system. In the ease of doing business index, we are placed 99. But on the enforcement of contracts, Sri Lanka is placed 164. Who is going to come here? Who is going to come here? We set up a commercial courts, right, at the beginning, but it hasn't given the desired result. And this was referred to earlier, a keynote address at the National Law Conference in June 2023 by the Justice Priyantha Jayawardena President's Council that was made. With the permission of the chair, because I don't have time, I would like to actually table this only for the reason that there are many recommendations in this, and therefore whether this speech could be tabled, because there are many recommendations on laws delays and how to actually handle it. But if I were to just quote from it, he says, in my view, the answer is that it is difficult to do business in Sri Lanka. There is no investor-friendly environment, predictability on security for investments. Widespread bribery and corruption are deterrents in getting the business community to invest in Sri Lanka. The Commercial High Court was considered a success initially due to the appointment of judges with a firm grasp of commercial law. If one thinks that the judges can learn commercial law and civil law while serving on the bench, it is a big mistake. I believe that the appointment of judges to the Commercial High Court who are not conversant in commercial law has contributed to the present predicament. These are not my views. These are the views of a Supreme Court judge. I wish to now focus on how we have addressed the piling of cases in the Commercial High Court. At the time of establishing the Commercial High Court, the jurisdiction of the Commercial High Court was to hear matters arising from commercial contracts where the value was more than 3 million, subsequently increased to 5 million and going on to 50 million and so forth. in my opinion, the remedy is to adopt the old practice of appointing learned judges who are conversant in commercial law and to train them to hear commercial cases. So, lots of proposals, and that's why I was going to table it, because there is no time to go with it. Then, in addition to that, we have fundamental rights cases. And on fundamental rights cases, right, Article 126 says this. It actually has put a time limitation on the court in Article 126. And I'm just going to read an extract very, very quickly. Where in the course of hearing in the Court of Appeal into an application for orders in the nature of a writ or habeas corpus, certiorari prohibition, procedendo, mandamus, and quo warranto, it appears to such court that there is prima facie evidence of an infringement or imminent infringement of the previous provisions of Chapter 3 and Chapter 4 by a party of such application, such court shall forthwith refer such matter for determination by the Supreme Court. And then it goes on to say this, which is what's important. The Supreme Court shall hear and finally dispose of any petition of reference under this article within 2 months of the filing of such petition or making such reference. This is what the Constitution of the country actually says. And we say that we are governed by the Constitution of the country. The Supreme Court hides behind this thing, saying that this is only directory and it is not mandatory. I think that we need to look at it. There's a law and there's a spirit of the law. The constitutional makers put this 2 months. So I don't literally mean 2 months. But the spirit of the law needs to be understood, because they wanted a limitation on these cases actually being heard. We have unprecedented situations. We have members of parliament sitting here and people questioning whether they're citizens of this country. Unheard of in any other parliament in the world. Unheard of in any other parliament in the world. We have people who have crossed over, right? And processes go, expellings go from parties. Under this provision, these things need to be determined quickly. As I said, my debate today is not about individuals, it's about processors. It is fair by the member of parliament included that if they haven't committed an offence, that they are set free immediately. But if they have committed an offence, then they must be punished. And they must be punished very quickly. And we must not delay it. So this impinges on the franchise of the people. And this is one way in which the sovereignty that we have been given in Article 3 and 4 of the Constitution is being impinged by this violation. Then there is this, the validity on the expulsion of MPs is unbelievable. Article 99(13) says this, and I would like to read that as well. Right, so there are 2 places in which this is actually stated. Where a member of parliament ceases by resignation, expulsion or otherwise to be a member of a recognized political party or independent group on whose nomination paper hereinafter referred to as a relevant nomination paper, his name appeared at a time of his becoming such member of parliament, his seat shall become vacant upon the expiration of a period of 1 month from the date of his ceasing to be a member. Provided in the case of expulsion of a member of parliament, his seat shall not become vacant if prior to the expiration of the said period of 1 month, he applies to the Supreme Court by petition in writing, and the Supreme Court upon such application determines that such expulsion was invalid. We all agree up to that point about the 1 month and going to the Supreme Court. But here we are. Such petition shall be inquired into by 3 judges of the Supreme Court, who shall make their determination within 2 months of filing such petition. Where the Supreme Court determines that the expulsion was valid, the vacancy shall occur from the date of such determination. 2 months has been stipulated. In the Constitution of the country it has been stipulated. but none of this is actually being followed. Not the letter of the law, neither is the spirit of the law being followed. And what is the example that we are actually setting? So there are all kinds of issues. Today there is a general agreement that the exercise of civil appeals jurisdiction by the High Court has not produced the desired results, considering the large number of cases that are before the Supreme Court, taking up much valuable judicial time of the apex court of the country. So I would say to the ministers, consider the Court of Appeals sitting in the provinces could take up civil appeals as well as fundamental rights applications. I'm saying we have to look out of the box. I'm saying consider these things if we really want to see changes. We also see that increasingly more bills are being coming up, more bills. All the bills are being challenged by various parties, increase in the number of challenges of bills that are coming. And we also, I heard today from the ministers that you want to increase the law and you want to bring in new laws. All this is going to be challenged. And therefore the time of the apex court is going to be focused on this. Other people's judgments are also going to be pushed to the back. This adds up to delaying and disposing other cases before the court. So therefore I would again say something to consider. Consider as a solution a constitutional court to be set up, as has been done in many other countries. And for the constitutional court, you can have career judiciary, private and official bar, as well as legal academia. I'm saying look at out-of-the-box solutions to really solve this issue and maybe restrict people serving on it maybe for one term so that we can ensure the independence of the courts. Now, then I want to get into this issue about judges and their promotions. And I say
member, you have 2 more minutes.
I say this very sensitively, right? I don't know of any profession that doesn't look at performance and seniority. Performance and seniority both are important, and certainly in the judicial profession it is needed. But the performance indicator should be, as the minister referred to, the disposition of judgments. No judge who has a large number of judgments pending should be promoted. Yes, seniority, I stand by that. But surely, if he's having large number of judgments pending, then how can we? We are all professionals. Professional criteria must be applied. Performance and seniority must be applied. And I would say this to the bar as well. The bar must contribute in actually accelerating this process. And then, if people feel that if cases are disposed of quickly, our incomes might go down. It won't go down because people will get more confidence to come into the courts. Today's Daily Mirror says that the Caterers Association or somebody has made a determination that if you go and eat in a restaurant and you don't pay the bill, then they have to ask them to assault the politician or whoever who isn't paying the bill. What kind of crap is this? They should be going to court. They should be going to court. Why are the people talking like this? Because they have lost confidence in the judicial system of the country. And in closing, I would like to make this point on basically judicial administration. As was mentioned before, in 1994 on May 6, Srinath Lalaka Kumarasinghe brought this and suggested that basically we establish a separate judicial administrative authority.
Member, please wind up.
I'm winding up. Don't delay it. And during that time, he said that even Mr. Athulat Mudali was backing this idea and said there was no decorum in the court. And I would like to also say Mr. Srikanth also spoke about this, and he talked about the corruption in the system. And if I were in closing only to quote Mr. C.V. Gunaratne, he said, I'm happy to endorse the views on the proposal of the establishment of a separate judicial administrative authority. Sir, the concept of corruption prevailing in the courts is too well known, but corruption is not confined to the courts alone. It is rotten to the very core of our society. And he goes on, and this was in 1994. What's the difference today? Today people say it's much worse, corruption is much worse. And therefore, we need to tackle this. So I back the suggestion by Sagala Karyavasam, and I would say, while the ministers look at changing situations, a select committee on reducing laws on delays and building the confidence both of investors and citizens. Maybe a select committee should go into it. Thank you very much for the time given.